There's been a development in the matter of free speech in our country. Now, you know, last week the Supreme Court passed a verdict against Prashant Bhushan, holding him in contempt of court for two tweets he had put out in June. The first one was about the fact that the Chief Justice of India, Bobde, was seen riding a Harley Davidson superbike belonging to a BJP leader, and Prashant Bhushan questioned the fact that the court was not functioning at that time. In the second tweet, he questioned corruption within the court. Now, the court took suo motu cognizance of these two tweets and brought in a case of criminal contempt. And in that case, Prashant Bhushan was found guilty pending sentence. Today, 42 senior lawyers from across the country have released a statement with regards to that order. Now, the statement's very interesting. I'm going to quote some of it. It says, "This judgment does not restore the authority of the court in the eyes of the public. Rather, it will discourage lawyers from being outspoken." It also says an independent judiciary does not mean judges are immune to scrutiny and comment. And finally, it says that we're of the firm view that the judgment must be given effect to only after a larger bench sitting in an open court has the opportunity to review the standards of criminal contempt. Now, effectively, in a very long judgment against Prashant Bhushan, the court said that these two tweets scandalized the court and are therefore criminal contempt of court. Now, according to Article 19(1) of our Constitution, we all have freedom of speech and expression, but one of the exceptions of that freedom of speech is criminal contempt of court. So the question really is that these lawyers now believe that freedom of speech as we know it in our country will change if this one order is not challenged. Secondly, that this actually is not strengthening of the court and the bar. It in fact weakens the court and the bar. And they've fundamentally called into question the fact that two tweets cannot shake the credibility of the court. Joining us right now is Sanjay Hegde, one of the senior lawyers and the signatory of that letter, who has been very kind to give us his time and to explain to us why this letter was brought out to begin with. Mr. Hegde, thank you for joining us. My first question to you is this: would you be kind enough to explain to us why lawyers felt the need to put out this statement?
Well, this is a group of lawyers which is drawn from all over the country. The senior advocates from Bombay, the senior advocates from Gujarat, and there were all of us who sort of spontaneously came together and decided that, this was not something that we could keep quiet about. Because after all, when we speak of the judiciary, it is both bar and bench. The judiciary does not comprise the judges alone, and it is the joint strength and the harmonious relationship between bar and bench which determines exactly how strong the judiciary is. The judiciary's strength is something that concerns the bar as well, and the bar does not loosely make comments. If we are in a position where the highest court of the land in a judgment rules that two tweets by a member of the bar are enough to shake the foundations of the court, then sorry, we thought we had a much stronger institution than that. So this is an opportunity where the bar wants to tell the court and the nation, tell the judges and the nation, that we are as much concerned with the independence of the judiciary, and it is the independence of the judiciary does not solely mean immunity of the judges from scrutiny and peer review and public comment.
You have also in your letter asked that the matter be examined by a larger bench after the pandemic. Would you explain to us that demand and what these group of lawyers were hoping for?
Well, the thing is that these hearings commenced and finished during the pandemic, and during the pandemic we have only video conferences which are not necessarily open court, not everybody has access to it. These are matters of such moment. The definition of what constitutes criminal contempt, especially when it comes to comments from members of the bar in long standing, are things which should have been resolved in an open court when that was possible. There was no hurry to have this matter video conferenced and come out with a judgment. Even former Chief Justice Loda has commented on the speed and the hurry and there is a certain opacity of the procedure which does not bode well for judicial independence, both on that side as well as on this side.
If I may just ask you about a couple of points so we can understand them a little better. It does also bring out the fact that prior permission of the Attorney General is required for a suo motu case of this kind to move forward. Would you explain to us what the rules are and and how it was different in this particular case?
See, normally, if there is an accusation of criminal contempt, you need to take the permission of the Attorney General, because the Attorney General is seen as the guardian of the court's contempt. If the Attorney General feels that there is a case for somebody to be criminally prosecuted, he gives permission. That is one of the procedures laid down in the Contempt of Courts Act itself. And I know of cases involving Mr. Shanti Bhushan, where my senior, the then Attorney General G. Ramaswamy, said that I will not give permission because some of the allegations are against me, and then he sent it to the Solicitor General, who at that point of time I do not think exactly give permission. But the permission of the Attorney General is a procedural safeguard. Sometimes in contempt matters, even the court has to be advised by a senior independent law officer like the Attorney General in this as to what is the correct mode to proceed with. Of course, there are earlier judgments which say that the permission of the Attorney General is not an absolute must. There can be cases where the court can take it on its own motion. There are contempts and contempts. Let us assume that this is for argument's sake, that some man jumps up and slaps one of the judges while he's sitting in court. That's contempt in the face of the court. Then obviously there is no question of asking the Attorney General, is it contempt? Please tell us, Mr. Attorney General. But there are cases where the procedural safeguard is best adhered to. And this was certainly a case. This was something said on Twitter, something said by a lawyer of the court. There was nothing. And in here, the bench called for the Attorney General. They had him on video conference, and then they did not ask him anything. So we had the Attorney General hovering over the hearing like Banco's ghost, but having no effective role in the hearing at all.
Mr. Hegde, it actually just boils down to one thing, which is the freedom of speech and expression, Article 19(1)(a), of whether or not Prashant Bhushan's freedom of speech as a citizen of this country allows him the protection to say what he did. Is that fundamentally the argument that's happening here?
No, I think I'd like to correct you slightly.
Please.
Even freedom of speech is subject to the laws of criminal contempt.
Yes.
Among the various restrictions on it, criminal contempt, yes, defamation, etc. But the laws of criminal contempt cannot be so arbitrarily and overbroadly applied, so as to make the freedom of speech entirely nugatory. There have been earlier judgments, even by English judges, where contempt of court arose, saying that respect for the court must rest on firmer foundations, because at the core of everything is the freedom of speech. And to quote George Orwell, who was then quoted by former Chief Justice Gogoi in the Ramnath Goenka lecture, freedom is freedom to say that 2 plus 2 makes 4. If that is allowed, everything else follows. It can't be that freedom is freedom to say that 2 plus 2 may be 4 as long as I am not held in contempt. That is not freedom of speech.
Hegde, you brought up former Chief Justice Gogoi. There were 4 Supreme Court judges who held a press conference not long ago, bringing into question the independence of the court and its functioning. How is that different from this? Was that not also criticism of the court? And is this not criticism of the court? How are these 2 instances different from the point of view of this order?
Well, the 4 judges, senior judges of the Supreme Court of that day, said many things which, if they had not been sitting judges of the court, would, under this judgment, definitely be contempt. If it had not been Justice Chalameshwar, Justice Gogoi, Justice Kurian, and Justice Madan Lokor, if it had been an ordinary Madan Lokor, an ordinary Kurian, an ordinary Chalameshwar, or an ordinary Ranjan Gogoi, then going by this definition, it was certainly contempt. The judges in that conference essentially said that things were not right with the listing of matters in the Supreme Court, and that certain sensitive matters were all going towards one bench. Now, if any lawyer today were to say that under the Prashant Bhushan judgment, he would be certainly liable for contempt.
So going forward, effectively what you're saying is that unless challenged and reviewed, this judgment will have long-term impact on freedom of speech or our ability to criticize the judiciary?
Absolutely. I will not be able to tell any journalist writing a story about the judiciary, oh, go ahead, this does not constitute contempt. The standards of what constitutes scandalizing the court are now drawn in such a manner that almost anything could come under it. You must remember that there were previous attempts, previous cases which came up before the Supreme Court, where the law minister of the day, Mr. P. Shiv Shankar, said that the Supreme Court has become a haven for FERA violators and for dowry cases. Somebody took him up in criminal contempt. The Supreme Court did not convict him. On the other hand, it did convict Mr. E.M.S. Namboodiripad, who said that judges were used as instruments of class oppression. The Supreme Court then, in that judgment, went into a huge definition of Marxism and asserted that Mr. Namboodiripad did not know Marx. Mr. Namboodiripad then later gave his own rejoinder in a different way. But these are all interesting cases. All of them were people who were outsiders, except Mr. Shiv Shankar, who was not only the sitting law minister at that point of time, but who himself had been a High Court judge. This is the first time that a practicing lawyer of eminence who appears in the Supreme Court day in and day out has been told that his normal criticism of the court expressed on a public platform on social media constitutes criminal contempt because it tends to undermine the authority of the court. This phraseology is so vast, so broad that almost anything could come in. I have a story for you and your viewers. Many years ago, one of the chief justices of the day decided to put all the photographs of all the sitting judges outside the chief justice's court, so that people could look at their faces before they actually went into court. This is something odd, not particularly in great taste. A senior advocate of that day went to some of the judges and said, I saw those photographs. I was not sure whether if I lit an agarbatti or put on a garland on that photograph, it would constitute contempt or not. So this is exactly how broad the phraseology, scandalizing or threatening the authority of the court is. After the senior advocate said that, all those photographs went off. But if there's one more thing I want to say. If you define it very harshly, then what is going to happen is that the humor in the corridor is going to get much better.
Mr. Hegde, what is likely to happen now? In order for a larger bench to review this matter, will someone need to file for a review, or are you expecting this letter to result in that review?
If the court thinks institutionally, if all the judges get together and say, what do we do about this now? They will find their own way. I am told anyway that I read somewhere that Mr. Prashant Bhushan is filing a review. So the technical part of it can always be taken care of. But the first thing is, do the judges, all the judges of the court, affirm this view taken by a 3-judge bench? If they so affirm, then freedom of speech is in trouble, the bar is in trouble, and the court will possibly not be as strong as the bar imagined it to be, or at least as I imagined it to be.
All right, Mr. Hegde, thank you so much for explaining this to us and answering our questions. It has been a pleasure speaking with you.
Thank you. Thank you, Faye.